Hello everyone, and welcome back to the channel. I am Mr. Kelly, your immigration analyst. If you are a green card holder, if you are sponsoring a family member, if you are waiting in an employment-based green card line, or if you are thinking about becoming a United States citizen, today's video is one of the most important videos I have made this year. Right now, in April 2026, there are 4 specific groups of immigrants who have a rare window to file their applications. And I am not just saying this to get clicks. The data, the visa bulletin, and the latest USCIS announcements all confirm it. But here is the thing. These windows do not stay open forever. The Department of State has already warned that retrogression, that means dates moving backward, could happen later this fiscal year. So if you qualify, the time to act is right now, not next month, not next quarter. In today's video, I am going to break down exactly who these 4 groups are, what forms you need to file, what the deadlines look like, and what major rule changes could affect your case. I will also cover the biggest risks green card holders are facing right now in 2026, including a brand new loan ban, biometric tracking at airports, and USCIS case holds. Stay until the end because I have 7 action steps that every single immigrant in America needs to follow this month. Before we get into it, if you find this information helpful, hit that like button, subscribe to this channel, and turn on the bell notification so you never miss an update. Let us get started. Before I introduce the 4 groups, let me give you the big picture so you understand why this month matters. As of the latest available data, the United States Citizenship and Immigration Services has a record backlog of 11.3 million pending cases. Let me say that number again. 11.3 million. That is the highest number ever recorded in the history of the American immigration system. This backlog includes green card applications, work permits, citizenship applications, visa petitions, and asylum cases all sitting in a massive queue. Why is the backlog this bad? Application volume is at an all-time high because more people are filing than ever before. USCIS experienced staffing cuts when roughly 50 employees were terminated in early 2025, and hiring has not caught up with demand. New vetting and screening procedures were introduced, including social media reviews for H-1B, H-4, and now 14 additional visa categories as of March 30, 2026. USCIS also rolled out a digital system overhaul in 2025 and 2026, transitioning from paper-based filing to electronic payments and online submissions, and while this will speed things up long-term, it has caused temporary processing slowdowns during the transition. On top of all that, annual visa caps and per-country limits continue to create bottlenecks, especially for applicants from India and China. There is also a 75-country immigrant visa freeze that has been in effect since January 21, 2026. The State Department paused all immigrant visa issuance to applicants from 75 countries, citing public charge concerns. The only exception is for adoption cases. Multiple lawsuits have been filed to challenge this freeze, including cases reported by NPR, the National Immigration Law Center, and civil rights organizations. But as of today, the freeze remains in place. There is also an expanded travel ban covering 39 countries that went into effect on January 1, 2026. Now, here is the interesting part. Because visa issuance has slowed down for consular processing cases, meaning cases processed at embassies abroad, the demand for domestic visa numbers has decreased, and that has actually caused priority dates to move forward in the April 2026 visa bulletin. This is a direct benefit for people already inside the United States who can file adjustment of status applications. So the 75-country freeze is terrible news for millions of people abroad, but for certain groups already in the US, it has opened a rare window. That is exactly what we are going to talk about now. The first group that can apply right now is family-based applicants in the F2A category. F2A covers spouses of lawful permanent residents and their unmarried children under the age of 21. In the April 2026 Visa Bulletin, the F2A category is listed as current on the dates for filing chart. Let me explain what that means in simple terms. The visa bulletin has two charts. The first is the final action dates chart, which controls when your green card can actually be approved and issued. The second is the dates for filing chart, which controls when you are allowed to submit your adjustment of status application, even before a visa number is technically available to you. When a category is listed as current on the dates for filing chart, it means there is no priority date holding you back. You can file regardless of when your petition was filed. For April 2026, F2A is current across all countries on the dates for filing chart. That includes applicants from India, China, Mexico, the Philippines, and every other country. There is no cutoff date. If you qualify, you can file. But this is very important. USCIS must independently authorize the use of the dates for filing chart each month. That authorization is not automatic. You need to verify at uscis.gov/visa bulletin info that USCIS has confirmed the dates for filing chart is being used for family-based categories before you submit anything. For April 2026, USCIS has confirmed they are using the dates for filing chart for all family-sponsored categories. Here is what you can do right now if you are an F2A beneficiary. You can file Form I-485, the application to register permanent residence or adjust status. You can also concurrently file Form I-765 for an employment authorization document, which is your work permit. You can file Form I-131 for advance parole, which gives you permission to travel internationally while your green card application is pending. And you must include Form I-693, which is the medical examination form, with your initial filing. This is a critical change for 2026. The medical exam must now be included at the time you submit the I-485. If you do not include it, your application can be rejected. Another important update is that the COVID-19 vaccination is no longer required for the immigration medical exam. That requirement was removed effective January 22, 2025. So do not let anyone tell you that you need a COVID vaccine for your green card. That is outdated information. If the green card holder, the sponsor, has already filed a Form I-130 petition on your behalf, and that petition has been approved or is currently pending, you may be able to file Form I-130 and Form I-485 at the same time. This is called concurrent filing, and it is available when the dates for filing chart shows current for your category. Also, keep in mind that each form now requires a separate payment. You cannot combine the fees into one check or one payment. Form I-485 has a filing fee of $1,440, which includes the $85 biometric fee. Form I-765 and Form I-131 filed concurrently with I-485 currently do not have an additional fee, but always verify this on the USCIS website before filing. The Department of State has explicitly warned that retrogression may be necessary later in fiscal year 2026. If F2A dates move backward next month, this window closes. You could be waiting months or even years for it to reopen. This is not a scare tactic. It is printed in the April 2026 visa bulletin itself. The second group that should be filing right now is employment-based green card applicants in the EB2 and EB3 categories. Let me walk you through the April 2026 numbers because they are significant. On the final action dates chart, which is what controls actual green card approvals, EB2 for all countries except India and China is current. That means if you are from any country other than India or China, and you have an approved I-140 petition in the EB2 category, your green card can be approved right now. EB2 for India has advanced to July 15, 2014, which is a 10-month jump from the March 2026 bulletin that was at September 2013. This is not small movement. This is the kind of jump that affects thousands of Indian professionals who have been waiting over a decade. EB2 for China remains at September 1, 2021, with no movement this month. For EB3, all countries except India, China, and the Philippines are current on the final action dates chart. EB3 for the rest of world and Mexico shows a final action date of June 1, 2024. EB3 for India is at November 15, 2013. Now let us look at the dates for filing chart, which is the chart that controls when you can submit your I-485 application. USCIS has confirmed they will use the dates for filing chart for all employment-based categories in April 2026. This is huge because the dates for filing chart is more advanced than the final action dates chart, meaning more people can file. On the dates for filing chart, EB2 for all countries except India and China is current. EB2 India has advanced to January 15, 2015. EB2 China is at January 1, 2022. EB3 for all countries except India, China, and the Philippines is current. EB3 India has also advanced to January 15, 2015, which is now aligned with EB2 India. This alignment opens up strategic options for applicants considering porting between EB2 and EB3 categories. For EB1, all countries are current except China and India, which are both at December 1, 2023 on the dates for filing chart and April 1, 2023 on the final action dates chart. For EB5 investors, all set-aside categories, rural, high unemployment, and infrastructure, remain current for all countries. The unreserved EB5 category is current for all countries except China, which is at October 1, 2016. What does this mean practically? If your priority date is before the date listed on the dates for filing chart, and USCIS is using that chart, you can file your I-485 right now. Filing your I-485 gives you access to a work permit through Form I-765, travel permission through advanced parole on Form I-131, and the ability to change jobs more easily under AC-21 portability after 180 days. If you are an Indian national with a priority date before January 15, 2015, this is the moment you have been waiting for. After years of waiting, the line has finally started to move, and when it moves, you move with it. But I need to give you a warning. The Department of State noted that this forward movement happened partly because visa issuance slowed for certain nationalities due to the 75-country freeze and other policy changes. If those policies change or demand increases, dates could retrogress. Do not assume these dates will hold next month. The third group is green card holders who are eligible to apply for United States citizenship through naturalization using Form N-400. Here is why this is a particularly good time to file. As of early 2026, the national median processing time for Form N-400 is approximately 5 to 6 months. But the range is enormous. Some USCIS field offices are completing 80% of naturalization cases in under 3 months. Others are taking 13 months or more. The fastest offices are processing cases remarkably quickly, which means if you are in the right location, you could go from filing to oath ceremony in as little as 3 to 4 months. Who is eligible? Generally, you must have been a lawful permanent resident for at least 5 years, or 3 years, if you obtained your green card through marriage to a U.S. citizen and are still married to and living with that citizen. You must have been physically present in the United States for at least half of the required residency period. You must demonstrate good moral character. You must pass the English language test and the civics test, which covers 100 questions about American government and history. Some applicants over 65 who have held their green card for 20 or more years may qualify for accommodations on the civics test. Why should you apply now instead of waiting? Processing times are currently favorable, but USCIS has warned that the 11.3 million case backlog could slow everything down. So filing now gets you in the queue before things potentially get worse. U.S. citizens have stronger protections against deportation and removal than green card holders, and in 2026 we are seeing increased enforcement activity, including ICE operations at airports, workplaces, and even courthouses. A U.S. citizen cannot be deported. The new SBA loan rule, which went into effect March 1, 2026, bars green card holders from obtaining SBA-backed business loans, but U.S. citizens are not affected by this restriction at all. Citizens can also sponsor family members in preference categories that are not available to green card holders, such as married sons and daughters and siblings, and citizens can vote, serve on juries, and hold certain government positions. If you have been a green card holder for the required number of years and you meet the eligibility requirements, I strongly recommend filing Form N-400 this month. The filing fee is $710. You can file online at USCIS.gov. The fourth group is green card holders whose cards are expiring or have already expired. You need to file Form I-90, the application to replace permanent resident card. This is a time-sensitive issue in 2026 because processing times for Form I-90 have increased dramatically. As of April 2026, Form I-90 is taking approximately 8 to 12 months to process. That is double or even triple what it was a year ago, when processing took about 4 months. Some applicants are reporting wait times even longer than 12 months. Why does this matter? Your green card is your primary proof of lawful permanent resident status. You need it for employment verification on Form I-9, for international travel, for obtaining a real ID or driver's license renewal in many states, and for many other official purposes. If your card expires and you do not have a valid receipt notice or extension, you could face serious problems at work, at the airport, and at government offices. Here is the good news. When you file Form I-90, USCIS extends your green card validity for 24 months from the date on your receipt notice. That means even though it takes 8 to 12 months to get the new card, your old card plus the receipt notice together serve as proof of your status for up to 24 months. But you must file early enough to receive that receipt notice before your card expires. My recommendation is to file Form I-90 at least 12 months before your green card expires. I know that sounds early, but with current processing times, it is the safe approach. The filing fee for Form I-90 is $455, and you can file online at USCIS.gov. If your green card has already expired and you have not filed yet, do it immediately. Do not wait another day. An expired green card without a pending renewal can create problems with your employer, with TSA at airports, and with any government agency that needs to verify your status. Now that I have covered the 4 groups, let me talk about some critical changes and risks that affect all green card holders right now. These are things you need to know even if you are not in one of the 4 groups above. Effective March 1, 2026, the Small Business Administration issued a rule that bars lawful permanent residents from obtaining any SBA-backed loan. Under this new rule, every direct or indirect owner of a business seeking an SBA 7A or 504 loan must be a United States citizen or national. Even a 1% ownership stake by a green card holder disqualifies the entire loan application. In fiscal year 2025, the SBA approved 3,358 loans for businesses that were partly owned by lawful permanent residents. All of those businesses would now be disqualified under the new rule. This is a devastating change for immigrant entrepreneurs. If you are a green card holder who owns a business or is planning to start one, you need to explore alternative financing options such as conventional bank loans, private lending, or community development financial institutions. And if you are eligible for naturalization, this is another reason to apply for citizenship now, because U.S. citizens are not affected by this restriction. A final rule that took effect on December 26, 2025, mandates facial biometric capture for all non-citizens at every point of entry and exit, including airports, land borders, and seaports. This means every time you leave or re-enter the United States, your face is being scanned and logged. For green card holders, this creates a detailed record of your travel patterns. If you are spending more than 6 months outside the United States, CBP may question whether you have abandoned your permanent residence. If you are going to be abroad for more than 6 months, you should apply for a re-entry permit using Form I-131 before you leave. Do not assume you can explain your way through at the border. There have been reports of CBP officers at airports asking green card holders to sign Form I-407, which is the formal abandonment of lawful permanent resident status. If you sign this form, you are voluntarily giving up your green card. Do not sign it under any circumstances without speaking to an immigration attorney first. You have the right to refuse and to request a hearing before an immigration judge. On March 30, 2026, USCIS announced a new internal process for reviewing cases that were placed on hold as part of strengthened screening and vetting procedures. The good news is that USCIS has begun lifting holds for applicants from non-high-risk countries who have cleared the enhanced vetting process. The not-so-good news is that cases from certain high-risk countries may remain frozen indefinitely. If your case has been on hold for an unusually long time, you can submit an e-request through the USCIS website, call the USCIS Contact Center at 1-800-375-5283, or contact your congressional representative's office for a congressional inquiry. Effective March 30, 2026, the State Department now requires social media reviews for 14 additional visa categories, including K-1 fiancé visas, K-2 and K-3 visas, R-1 and R-2 religious worker visas, H-3 trainee visas, A-3 diplomat employee visas, G-5 international organization employee visas, Q cultural exchange visas, S informant visas, T trafficking victim visas, and U crime victim visas. If you are applying for any of these visas, your public social media accounts will be reviewed. Inconsistencies between what you post online and what you state on your application can trigger delays, requests for evidence, or denials. Review your social media before you file. As of April 1, 2026, USCIS will only accept the new edition of Form I-129, Petition for Non-Immigrant Worker, dated February 27, 2026. Any petition submitted on the old edition dated January 20, 2025 will be automatically rejected. This is critical for employers filing H-1B petitions, especially those who won the FY 2027 lottery. The filing window opened on April 1, 2026 and runs through June 30, 2026. If your employer files on the wrong form, the petition is dead and the fee is lost. Now let me give you 7 concrete things you should do this month. If you are a spouse or child of a green card holder and your F2A category is current, start preparing your I-485 package immediately. Get your medical exam done now. Go to a USCIS designated civil surgeon, get Form I-693 completed and sealed, and include it with your I-485 filing. Remember, separate payments are required for each form. If you are an employment-based applicant with a priority date that is current on the dates for filing chart, file your I-485 with your employer's cooperation this month. Include Form I-765 for your work permit and Form I-131 for advance parole. Talk to your employer and your immigration attorney immediately. If you have been a green card holder for 5 years or 3 years through marriage and you meet all the eligibility requirements, file Form N-400 for naturalization. Processing times are still relatively fast at many offices, and citizenship gives you protections that a green card does not, including protection from the SBA loan ban, stronger defenses against deportation, and the ability to vote. If your green card expires within the next 12 months, file Form I-90 now. Do not wait until 3 months before expiration. With processing times running 8 to 12 months, you need to file early to ensure you have a valid receipt notice before your card expires. Check the visa bulletin every single month. Go to travel.state.gov and look at both the final action dates chart and the dates for filing chart. Then verify on the USCIS website which chart USCIS is using for your category that month. This takes 5 minutes, and it could change your entire timeline. If your case has been on hold, or you have not received any update in an unusually long time, take action. Submit an e-request through the USCIS website. Call the USCIS Contact Center at 1-800-375-5283. If those do not work, contact your congressional representative and ask them to submit a congressional inquiry on your behalf. Do not just sit and wait. Consult with an experienced immigration attorney, especially if you are dealing with a case hold, the 75-country visa freeze, the SBA loan ban, travel concerns, or any request for evidence. Immigration law is complex, and the rules are changing rapidly in 2026. A qualified attorney can help you protect your status and make the best decisions for your situation. The USCIS backlog stands at 11.3 million pending cases. 75 countries are under an immigrant visa freeze. 39 countries are under an expanded travel ban. Green card renewal processing time is 8 to 12 months. Naturalization processing time is 5 to 6 months nationally, with some offices completing cases in under 3 months. The SBA loan ban affects any business with even 1% green card holder ownership. EB2 and EB3 for rest of world are current. EB2 India has advanced to July 15, 2014 on the final action dates chart, and January 15, 2015 on the dates for filing chart. F2A is current for filing. The new Form I-129 edition is mandatory as of April 1, 2026. The I-485 filing fee is $1,240. The I-90 filing fee is $455. The N-400 filing fee is $710. Let me leave you with this. The immigration system in 2026 is challenging. There is no question about that. The backlog is enormous. New rules are rolling out every few weeks, and enforcement is increasing. But within all of that uncertainty, there are real opportunities right now for people who are informed and who act quickly. If you are in any one of these 4 groups, F2A family-based applicants, EB2 and EB3 employment-based applicants, green card holders eligible for naturalization, or green card holders who need to renew their cards, do not let this window pass you by. File now. Prepare your documents. Talk to an attorney. And check back on this channel because I will keep you updated every time something changes. If this video helped you, hit the like button. Share it with someone who needs to hear this. Subscribe to this channel and turn on that bell notification so you are the first to know when new immigration updates drop. Drop a comment below and tell me which group you are in. Are you F2A? EB2? EB3? Filing for citizenship? Renewing your green card? I want to hear from you. This is Mr. Kelly, your immigration analyst, and I will see you in the next video. Stay informed, stay prepared, and keep moving forward.